And as a result of his actions in this case, the OLR requests that this court find that he did violate counts 2 and 3 of the disciplinary case as found by this referee. And the OLR recommends that this court impose a 60-day suspension of his license.
You think that the third count is contrary to the First Amendment?
Is it covered under the First Amendment? Under the Gentile case, there's a balancing test that you look at in determining whether or not actions or speech are covered under the First Amendment. You have to look at whether or not his right to make statements or comments about the district attorney's office and the judges in this case outweighed the state's right to a fair trial or the public's right to a fair trial in this case. If you look at the facts and circumstances of this case, if you look at the details of the analysis, the materials that are contained in Mr. Sommers' pretrial publicity, if you look at there's one page called the Raceback Case Made Simple that contains expert analysis. One of the experts on that analysis is an expert whose the information was provided to Mr. Sommers through pretrial discovery. It was not made public. It was not in the court record. You also have an analysis of Robert Krenz's expert testimony, who in the JusticeDaneCountyStyle.com internet site. All of that information, particularly with regard to Robert Krenz, was excluded from trial. Robert Krenz was not allowed to testify at trial with regard to any of those facts. All the information, a majority of the information about the Dane County District Attorney's Office, the judges, experts' opinions were not admissible at trial. Any juror that had their hands on that information, it could potentially prejudice their thoughts, feelings, processes at the trial level. Clearly,
you handle that on voir dire and striking jurors. This was all before trial, right?
This was all before trial. However, you need to weigh the impact of the public dissemination of information that Mr. Sommers put out there versus the state's right to a fair trial. If this evidence or information was disseminated to the public, that has a high likelihood of prejudicing the trial. And that needs to be taken into consideration. If you look at the matter of Stephen Litt's case, which is an Indiana Supreme Court case, in that case, there was an attorney's letter to the area newspapers where the attorney made extrajudicial statements during his client's retrial. He asserted his client's innocence, criticized the prosecutor's decision to retry the case, and included information in there that his client had passed a lie detector test. In that case, the court held that there was a substantial likelihood that the information that the attorney in that case disseminated to the public would materially prejudice the jury trial. And I believe if you look at all the information that was contained within the newspaper articles, and particularly within the website, which was referred to in the newspaper articles, I believe that all that material together would there's a substantial likelihood that it would impact the trial in this case.
I'm assuming that the OLR does not automatically check our decisions or those of the Court of Appeals or the trial courts when there's accusations within them that either the defense counsel or the prosecutor engaged in misconduct. Is that right?
No.
You do not check all those?
No, we do not. Not that I'm aware of.
All right. Thank you, counsel.
Ms. Scott, I have one last
Justice
question.
Brooks.
Following up on what the Chief Justice was asking you, my understanding is that there were 3 different judges involved in this matter. Maybe I'm missing somebody, but first Judge Higginbotham, then Judge Bukowski, then Judge Moser. Did any of those 3 judges issue a gag order to the attorneys in regard to what could or could not be said prior to trial or during trial?
No. I'm not aware of a gag order being put out.
If I may, refresh my recollection with regard to that part of count 3, I think it was paragraph 61 to 53, that dealt with putting a flyer on potential jurors' windshields.
Sure.
What happened with regard to that?
There's no allegation that Mr. Sommers actually, in fact, put out those flyers. The reason that the flyers are an issue is because there's evidence and testimony that those flyers contain the same or similar language to language that was contained in Mr. Sommers' websites. It contains a lot of the same allegations, the same factual analysis, and the flyers are essentially evidence of the effect of Mr. Sommers' pretrial publicity. Whether Sommers was involved or not, somebody took the information that was set forth or put out by Mr. Sommers and placed them on these flyers. And one of the concerns about at least one of the flyers is one of the flyers was in fact placed on, there's a level in the Dane County parking ramp, or the previous Dane County parking ramp where all the jurors are assigned to park. And on May 24th, 2004, there was going to be voir dire with regard to the trial in the raceback matter. Those flyers were placed on the same level in the parking ramp in which the jurors parked for voir dire for the raceback trial that day. And so, just in sum, these flyers were evidence of what happens when you place that type of information out there and it gets promulgated to the public.
Was there any indication during voir dire that those flyers or any other pretrial publicity was heard by any juror or infected any juror?
I don't believe that because this was the May 24th, 2004 hearing in front of Judge Pikowski, I don't believe that there was any voir dire done on that day because the trial was continued. There was
a voir dire. I've been reading some of this stuff, and there's a lot to read. There was a voir dire done, and if I recall, there was a juror that was struck because of knowledge of Mr. Humphrey. Correct me if I'm wrong, but I don't think any juror was struck with regard to any pretrial publicity. I believe ultimately, I'm just going from my memory at this point, I believe that when voir dire actually did occur for the trial, that none of the jurors were struck due to pretrial publicity. That's my understanding. Any other questions?
Anyone else? Any other questions? Thank you, Ms.
Thank you.
Scott. Mr. Sommers, you have 10 minutes on a not overly fast clock.
Okay. Your Honor, I will begin with where she left off. Actually, her last statement is factually not accurate. And it's critical, and it's understandable, and I don't see how she could have gotten it wrong, and this Court should know because it's been pointed out both in my brief and my reply brief, and the record says it. There was indeed a juror who was struck in voir dire. He was struck because of the pretrial publicity in that case. He was struck because he was biased against Raisback. And why was he biased against Raisback? Undoubtedly because Channel 27 had been fed a story that was put on the air prior to the trial, that Raisback, at the speed of the trial, that the state was going to be proving that Raisback was driving in excess of 100 miles an hour, when in fact at that time the state's position was the speed could not have been more than 76 miles per hour. Channel 27 retracted their story on their website. They refused to do so on the air. But that was the bias that was against Raisback at trial. Of course, nothing that I could have remotely been connected to could have even come close to being the equivalent of this planted false story which was Channel 27 ran with. In regards to three things that she brought up, I would like to touch upon. First,
I want to ask you something
Sure.
before you get started. Why did you give the interview to Isthmus? What did you think you were doing?
Actually, I'm not 100% on that. I don't really recall it. But if my memory is correct, Paul Humphrey was interviewed in that same issue. So we both were interviewed at the very same time. Second, in regards to that, as this Court knows, and that was one of the things I was going to touch upon, There is an exception to the rule, and the exception says an attorney can go public, warning of a danger concerning the behavior of a person involved when there is reason to believe that there exists the likelihood of a substantial harm to an individual or to the public interest.
Who did you think you were warning if you're going to use that?
One was the public.
Well, who?
All right, should the public be warned that a district attorney's office has, one, knowingly commenced a vehicle homicide when they knew their evidence was false? Two, should the public be aware that a district attorney's office knowingly utilized falsified testimony in order to have the individual bound over in the case to proceed?
So you wanted to put your view of the facts before the public, and that's why you did the interview?
Actually, I wanted, at that point in time, for the same reason, I mean, at these periods of time, I wanted the responsible people to step in. I had already gone to the court. Adam Raisbeck is a small man today. He was a smaller man back then. I think he was a 17-year-old kid, or not 17, 18-year-old kid. We're talking about convicting a kid from a criminal conspiracy. No, Your Honor. You're asking me why. That's why.
Slow down,
right,
okay? Slow down, Counselor. You're a fine advocate. You're a fine advocate, and I'm not trying to get in the way of that. I'm just trying to understand what occurred here in light of what you've been charged with, okay? And you've been involved in this for years, though I can tell you I've spent many, many hours and hours reading stuff. I don't know a tenth of what you probably know. So if you listen to me and answer my questions, you can probably help me out. And my question was, first of all, why'd you give the interview, okay? So you're telling me you gave the interview to warn the public. Well, you gave the interview prior to trial. Why did you give it at that time if you wanted to warn the public?
Because, Your Honor, I was authorized to do so by the Supreme Court rules. That's the thing that nobody wants. That's one of the elephants in the room that nobody wants to go.
I'm not worried about, Counselor, I'm not worried about the rule. I'm trying to figure out factually why did you do what you did. And you were not reading the Supreme Court rule before you went and had an interview with Isman.
Yes, I did, Your Honor.
So you read the rule and you decided this is what I should do under the rule?
I did look it up. Yes, Your Honor, I am a responsible man. At that time, I had 9 kids. I am not reckless when it comes to supporting my family.
All right, if you tell me
I did. I looked it up. Okay. That's the whole point. That's the elephant in the room, of course, that everybody wants to ignore, and it goes back to one of the key things. This court, basically, through the Chief Justice, gave what if, basically, whether it's true or not. The fact of the matter is, it is true, and it's not because I say so. It is very inaccurate to say that I say so. That's why the 6 days of evidentiary hearing had to be put on the kibosh. That's why they need to be excluded from the record. Because what took place in those 6 days of evidentiary hearing? What was testified to? 1, Krenz testified. Before they commenced the prosecution, they knew the evidence that Humphrey was using was invalid and falsified. That's part of the testimony. 2, the statement that Krenz testified to on Humphrey's behalf was false. Krenz conceded he could not have truthfully said that. 3, Nasinski testified. They then came up with a second falsified analysis in the presence of him, Krenz, and Humphrey. 4, Nasinski testified. The photographic evidence that proved the whole thing was false. Humphrey literally told him to remove that photographic evidence from a deputy's locker, bring it to Krenz's office, and it was falsely represented in court that neither Nasinski nor Humphrey knew where the exculpatory evidence was. And 5, Humphrey's own subordinate testified that the warrant, the affidavit to get the warrant on McCoy was false. 6, the detective testified that the statements that Olivar gave her, had put in her mouth in order to justify the allegation on count 1 were not true. She never said those things. She never could have said those things. Those are the things that all came out at those evidentiary hearings. And when she says, I have an affirmative defense, my God, that sins against the light. I was told after 6 days of evidentiary hearings that the evidence didn't count, literally didn't count. All you have to do is look at the referee's order and decision. The name Krenz never comes up. The name Nasinski never